My young friends, today we shall discuss the right to freedom, which consists in Article 19 to 22 of the Constitution of India. To start with, the Constitution of India guaranteed certain freedoms to the citizens, that is, the liberty to act and speak without interference from anybody. This provision of guaranteed freedom is enumerated in Articles 19, which is popularly known as 6 freedoms of the citizens, and these were previously known as 7 freedoms. But one of them, that is freedom to acquire, hold and dispose of property, has been omitted by the 44th Amendment Act of 1978. The existing 6 freedoms are freedom of speech and expression, freedom to assemble peacefully and without arms, freedom to form associations or unions, freedom to move freely throughout the territories of India, freedom to reside and settle in any part of the territories of India, and freedom to practice any profession or carry on any occupation, trade or business. These freedoms, which are guaranteed under Article 19, Clause 1, are not absolute, but are subject to the reasonable restrictions. The Constitution itself conferred freedom to the citizens, and this Constitution itself conferred powers enabling the states to impose reasonable restrictions in the exercise of the freedom by enacting laws. The citizens are given the freedom of assembly, but the freedom is subject to the fact that the assembly must be peaceful, and that too without arms. The state may put further restrictions in the interest of public order, meaning thereby that the right to convene a meeting or an assembly will not carry with it to create public disorder or to create breach of peace and public tranquility, which is to the prejudice of the sovereignty and integrity of India. The role of the courts will come into picture in cases where there is individual complaint to a court that his fundamental freedom has been violated by the operation of a law. In such case, the court is to determine as to whether the restrictions imposed is reasonable. If the court finds the restriction to be unreasonable, then it will declare the law to be unconstitutional and void for this reason. The expression reasonable restriction requires explanation. The view of the Supreme Court in its judgments entitled Lakshmi versus State of Uttar Pradesh, reported in AIR 1981, Supreme Court 873, is worth quoting. As to what are the reasonable restrictions would naturally depend upon the nature of the and the circumstances of the case, the character of the statute, the objects which it seeks to serve, the existing circumstances, the extent of the evil sought to be remedied, as also the nature of the restraint or restrictions placed on the rights of the citizens. It is guaranteed under Article 20 of the Constitution and affords protection in respect of conviction in commission of offences. The article directs the accused persons who are charged with the commission of offences and can be enumerated in the three headings, that is, firstly, protection against ex post facto laws, and secondly, protection against double jeopardy, and thirdly, protection from compelling to be a witness against himself. Article 20, Clause 1 of the Constitution affords the protection to an accused person conviction on the basis of an ex post facto criminal law. Ex post facto, the law imposes penalties retroactively, that is, upon acts already done, which has two parts. The first part is no person to be convicted of an offence except for violation of a law in force at the time of the commission of the act charged as an offence. The second part of the article immunizes a person from a penalty greater than that which he might have incurred at the time of committing the offence. Clause 2 of Article 20 provides, no person shall be prosecuted and punished for the same offence more than once. The implication of the article is that if a person has been prosecuted and punished in a previous proceeding of an offence, he cannot be prosecuted and punished for the same offence again in a subsequent proceeding. The root of the rule is to be found in the maxim of the English common law, nemo debit bis vexari pro una et idem causa, meaning that no man shall be vexed twice for the same fault. If a man is indicted again and again for the same offence in a court, he can plead as a complete defense by producing the fact of his acquittal or conviction. This is technically called autrefois acquit or autrefois convict. The Indian provision enunciates only the principle of autrefois convict, but not that of autrefois acquit. This is third part of the Article 20, that is Article 20 Clause 3, which is a privilege against self-incrimination. This is a fundamental principle of common law criminal jurisprudence. Under this principle, an accused is deemed to be innocent till the guilt is proved against him. The prosecution is to prove the case beyond reasonable doubt, and the accused need not make any statement against his will. Right to life and personal liberty is provided in Article 21 of the Constitution, which runs as follows. No person shall be deprived of his life and personal liberty except according to the procedure established by law. Fundamental rights are available against state action. Therefore, meaning of this article is that the executive shall not be entitled to interfere with the liberty of a citizen unless such an act of the executive has some legal support. The expression life and personal liberty in Article 21 has been interpreted by the Supreme Court in Kharak Singh versus State of Uttar Pradesh, which is reported in AIR 1963, Supreme Court 1295, and it was interpreted very liberally. It has quoted the observation of field justice in Mann versus Illinois, an American case. The meaning of life has been interpreted as to mean something more than mere animal existence and includes the right to the possession of each of the organs, his arms, legs, etc. The term personal liberty has been defined to mean not only freedom from arrest and detention or from false imprisonment, but also the variety of the rights of a person which go to make up the personal liberty of a man, which may not fall within Article 19. The right to privacy is held to be not absolute, and reasonable restrictions can be placed thereon in the public interest, as under Article 19, Clause 5. It is pertinent to point out here that right to privacy in India, which was unfolded from the fundamental right of speech and expression, and life and personal liberty is seen to be indicated in the Right to Information Act 2005 in India. Under this article, the state shall provide free and compulsory education to all children of the age of 6 to 14 years in such manners as the state may by law determine. This article is inserted by the 86th Amendment Act of 2002. Under this article, the manner of providing free and compulsory education to the children of the age of 6 to 14 years is entrusted to the state in the form of imposing a positive duty. The Parliament of India has, in implementing the article, passed the law entitled The Right of Children to Free and Compulsory Education Act of 2009. In order to give effect to the provisions of the Act, the central government has framed the rule entitled The Right of Children to Free and Compulsory Education Rules 2010. This Article 22 ensures 4 safeguards for a person who is arrested. Those safeguards are: firstly, a person arrested shall not be detained in custody without being informed of the ground of arrest. Secondly, such a person shall not be denied his right to be defended by a legal practitioner of his own choice. Thirdly, such a person arrested and detained in the custody is to be produced before the nearest magistrate within a period of 24 hours of his arrest, excluding the time necessary for the journey from the place of arrest to the court of the magistrate. The fourth aspect, that is, no person to be detained in the custody without the authority of the magistrate. These safeguards are, however, not available to an alien enemy, and in case of a person arrested and detained under a law providing for preventive detention. When a person has been arrested under a law of preventive detention, the government is entitled to detain such person in custody for 3 months. If it seeks to detain the person for more than 3 months, it must obtain a report from the advisory board which will examine the papers submitted by the government and by the detainee in order to see whether the detention is justified or not. And a law which violates any of the conditions imposed by the Article 22 is liable to be declared invalid. And any order of detention which violates any of these conditions will equally be liable to be invalidated by the court, and the detainee will be set at liberty. The Parliament has power to prescribe by law the maximum period for which a person may be detained under a law of preventive detention. The right to life and personal liberty is expanding the protection in respect of conviction of offences, immunity from double punishment, freedom from compelling an accused person to make self-incriminatory statement, and protection against arbitrary arrest and detention are the various other aspects of freedom. These articles are not mutually exclusive.